Hello, welcome, and a big thank you to everyone for joining us on this webinar, Product Recall UK and Australian Perspective. My name is Glyn Lloyd, Head of Liability, Charles Taylor Adjusting, Australia. I'd first like to cover some housekeeping items before introducing our speakers. Please note that this session is being recorded and we will send attendees a follow-up email with a copy of the recording. At the end of the webinar, you will see a short survey. This should only take a couple of minutes to complete, and we'll be very grateful for your feedback and suggestions for future events. Just so you're aware, all attendees are muted. However, if you do have any questions throughout the presentation, please type them in the question box on your side panel and we'll address them at the end. Now, for the important people on this particular presentation, obviously the presenters. Adrian Foster, Associate Director, UK. Adrian is a regular speaker and writer on topical liability issues ranging from data security to policy interpretation. He specialises in product claims ranging from food and drink to building products, mainly for the UK market. Martin Stebbings, Executive Liability Adjuster, living and working in Sydney, Australia. Martin is recognised as a leading practitioner in product claims and has dealt with some of the largest recall claims both within Australia and overseas. Nick Patterson, UK and International Casualty Director based in the UK. Nick has considerable experience of handling high value and complex claims, including product liability, product recall, both in the UK and overseas. And I'm sure that all of our panelists won't thank me for mentioning that they have almost 100 years of experience between them all. So, why Charles Taylor? Well, we have market leading experience across numerous industry sectors, automotive and component manufacturers, food and drink, medical equipment, building products, wind farms, just to name a few. We are regularly instructed on claims for insurers and reinsurers within conventional and non-conventional covers. We frequently deal with major losses which have cross-market exposures and significance. We have multidisciplinary skills with in-house accountants, engineers, and a variety of other experts and specialists. Our capability to deal with losses both nationally and internationally, as evidenced by this particular Anglo-Australian webinar, proves a point that we work in a collaborative and hopefully seamless manner across all product lines. I'd now like to hand over to our first speaker today in the UK, Adrian Foster. Adrian, thank you.
Hello everyone. I'd like to talk about policy cover and some of the issues arising. I'd like to very briefly discuss the cover under a product liability policy and then go on to discuss the cover available under a recall/rectification cover, discussing both the cover available, exclusions, and then finishing with a brief case study. Product liability cover, as opposed from product recall cover, responds only to third-party losses, and they're usually losses resulting from physical damage and the direct economic losses resulting from that physical damage. Product rectification is nearly always excluded under a product liability policy, and sometimes that is at the expense of other items that would be subject to an indemnity. In the UK, there is a case of Rexadan International v CU 1997, which makes that point very clearly. Within product liability cover, there may be financial loss extensions, which provide cover for pure financial loss, and there may also be some product recall extensions, though they have or usually have a very low limit of indemnity. Turning now to the product recall rectification cover, it's important to recognise that it is nearly always on a bespoke wording. It is not just a bespoke wording for the individual insured, but also a bespoke wording between insurers. Whilst I'll talk about some aspects that may well be standard cover and some that may well be extensions, each insurer's wording will differ, so that a standard cover for one insurer may well be an extension for another, and vice versa. It's important with every product recall rectification claim to have a copy of the exact wording and to review it in detail to determine what is subject to an indemnity. The cover can be roughly separated out into recall cover, guarantee cover, and crisis management cover. Let's just quickly have a look at the last point, crisis management cover. It's a separate section of the policy. There is usually a condition that a nominated firm of crisis management consultants is informed of the need for a recall. That may well be a condition for the policy in terms of the other cover, the recall or rectification cover applying. It's important to recognise as well that the crisis management company's documents and investigations cannot usually be relied upon by insurers or any advisors such as adjusters appointed by them to determine later policy cover. It's essential that the adjusters are allowed then to carry out their own inquiries independent from the crisis management company and their conclusions. The product recall guarantee cover is nearly always on a claims made basis with a retroactive date for the date the product was supplied. The excess on recall cover is often in excess of £50,000. This ensures that any small minor recalls or recalls of a single line with some supermarket charges, etc., are not subject to an indemnity and can be dealt with by the insured in-house without insurers incurring any policy liability. The policy will respond to insured events, which generally include accidental contamination, malicious tampering, and product extortion. The standard cover or an extension may also cover government recalls, adverse publicity, and other bespoke risks. You will note that all of those potential insured events are headed with capital letters, and that will denote their definitions under the policy. It's important again to review the individual policy to see what definition each insurer has provided for accidental contamination, malicious tampering, etc. One of the main areas of cover is accidental contamination, and with respect to property damage, the cover for accidental contamination is subject to a requirement that the insured's product has caused or would cause physical property damage other than damage to or destruction of the insured's product. It is often the case that the wording means that impairment is not enough to trigger the cover. With respect to personal injury, the cover for accidental contamination is subject to a requirement that there is a risk of identifiable internal or external physical symptoms of bodily injury, sickness, disease, or death of any person or persons within a set period of time. That set period of time, in the case I've quoted here, might be 120 days, but it could be another period. The important is that someone must suffer an injury, have some element that affects their health in some way. The consequence is that the policy would not respond without that injury being suffered. So, for example, the discovery of a rat infestation within the insured's premises is unlikely to be sufficient to trigger the policy cover. The insured's products, as defined in the policy, are normally those supplied by the insured and those into which the insured's product has been incorporated. This provides or brings into cover any third-party recalls, provided it is the insured's product that has triggered the need for the recall. The policy will then provide an indemnity for a list of recall costs. Again, recall costs has capital letters and will be defined within the individual policy, but generally they will include a variety of normally associated recall costs, plus some unusual items or items that have been added on by the relevant insurers, such as the cost of advertising a recall if one is required, the costs of tests or inspections to confirm the condition of any product supplied, or additional warehousing costs incurred in storing any recall products. Rectification costs can extend to the product which has not left the insurer's premises, and other areas where product might need to be reworked. The policy may also provide cover for loss of gross revenue and any rehabilitation expenses, such as those incurred in returning the product sales to the projected level of sales or market share anticipated prior to the insured event. To determine those at Charles Taylor, we often use our internal accountants to ensure that we've fully considered where the insured business expected the product sales to be and how they have been affected. I'd like now just to discuss some of the policy exclusions. It's important that the contamination must be accidental in nature. The policy will not respond to events after the insured has actual or constructive knowledge of the defect. This is an area that often requires detailed investigation to ensure the extent and to determine the extent of the insured's knowledge during their development of the product, during their release of it to sale, and when they first became aware that a product recall may be required. It is often the case that the insured will know of issues or aspects of their product, and we need to examine carefully whether these may have put the insured on notice. The policy will also not cover gradual deterioration of the product supplied, unless sudden in nature. This excludes any products simply being left and then sold when they're unsuitable for sale. It also will not cover penalty charges. This is where supermarkets may provide, for example, a flat fine to recall product lines, etc. Though some policies can provide a small extension for what is termed unsubstantiated costs, so that some elements of those supermarket fines will be subject to an indemnity. This is particularly common with food suppliers, where the use of supermarket fines to avoid detailed calculation of losses is accepted within the industry, or at least known within the industry. The policy will not cover losses or the need for a recall resulting from a change in government regulation. It also will exclude specific causes, such as genetic modification, irradiation, TSE, which is BSE or mad cow disease. There is one other key exclusion that may apply in respect of some policies subject to the wording, and that is where the insured's product has failed to perform its intended purpose. This is termed an efficacy risk or a business risk. In the UK, there are two key cases, Wave v Signa and Nitan Steel, which define that in terms of when the insured has failed, when the product has failed to perform its intended function, as opposed to when it's actually caused damage to third-party property. It should be noted, and it's important to note, that recall insurance is written to dovetail in with traditional product liability cover and financial loss extensions. Cover may, however, be provided by different insurers, so there could be duplication or gaps in cover, and these need to be assessed and considered. I'd like to finish my brief talk with a case example. It's some of the information, I'm afraid, isn't there simply because we've had to anonymize it, to remove any confidential information, etc. So some of the terms are general. This is a case example from 2006. The insured imported from China some herbs which they repacked and sold as food ingredients. The insured later found out that the herbs were irradiated and thus breached the UK Food Control of Irradiation Regulations 1990. By the time the insured found out that the herbs had been irradiated, they had been used to produce various food products, some of which were on the supermarket shelves. The product recall cover would not apply, as there was no risk to human health from the irradiated herbs, and also because under most modern wordings, irradiation of the insured's product is excluded. The product liability policy responded to the extent of the other undamaged and third-party ingredients which had been added to the chives. In this respect, the case of Rexadan was considered, and the UK case of Bacardi was ignored in terms of its potential application. The product liability policy excluded any recall costs, whether third or first person. However, the policy's financial loss extension, which had a £250,000 limit, did not exclude third-party recall costs. By presenting them as third-party costs, they were a financial loss, therefore picked up under the financial loss extension, and there was no specific exclusion for third-party recall costs, only the insured's own recall costs. The penalty charges that were applied by some of the supermarkets were excluded as there are a liability arising only in contract. That finishes my talk. I'd like to pass over to my colleague, Martin Stebbings in Australia.
Thank you, Adrian, and hello, everybody. Welcome to Sydney. My presentation is 15 minutes on regarding food and beverage matters and recalls. I'm going to look at the UK-Australia Free Trade Agreement, examine some food safety issues, and look at policy operation and recall examples here in Australia. A free trade agreement between Australia and the United Kingdom was implemented in June this year. It meant the removal of import tariffs. The UK is Australia's largest market for wine. Australian wine exports to the UK totaled 251 million litres last year. That's about 4 litres for every person in the UK. Under the Free Trade Agreement, Australian quotas for meat and other produce are set to rise with a staggered and staged removal of agricultural trade barriers planned over the next 15 years. Britain exports the equivalent of a bottle of whiskey each year for every Australian. Food exports from the UK to Australia of significance include confectionery and biscuits. Well, what's in the free trade agreement for the UK? Well, it's an important step to enable the UK to gain admission to the Trans-Pacific Free Trade Agreement and a market worth £9 trillion annually, or 15% of the world economy. Moving on to my next slide. I just got that the screen forward, just bear with me a minute, please. Firstly, technology. Well, there we go, here's technology for you. Examples of risk improvements in technology are complex machines becoming easier to use with automated machine learning, features such as multi-frequency scanning and magnetic separators. Data capture has improved, involving better ability to segregate and aggregate stock. We've come a long way since the Universal Product Code was first introduced for mass production in 1974. 2D barcodes allow for quick response, fast data access, and point of sale information. There's improving safety as a result of more legislation. In Australia, the Competition and Consumer Act 2010 provides the Australian consumer law. This provides for regulations for consumer goods, including provisions for goods to be of acceptable quality, fit for purpose, and to match description. Where goods are imported from overseas, Australian importers are primarily liable for losses in Australia caused by product defects. The Australian consumer law has introduced a national approach to the issuing and enforcing of product recalls. There is mandatory reporting for all participants in the supply chain and strict time limits. It provides for fines of up to $10 million or 10% of annual turnover, whichever is the greater. The regulator has a wide power to issue matters such as enforceable undertakings, notices, or various orders. There is the provision for criminal penalties to include a maximum of 2 years imprisonment. Food safety risk is also improving or increasing, depending which way you may regard the matter, through improving consumer knowledge and awareness. For example, the Australian Food Safety Information Council's annual Food Safety Week, which is next week. The regulator in Australia and New Zealand, Food Standards Australia and New Zealand, provides primary production standards, regulations for labelling, matters such as food identification warnings and declarations, ingredient statements, date marking, directions for use and storage, nutritional regulations. It provides a compendium for microbiological criteria, and it allows the state and territory food agencies and the Commonwealth Department of Agriculture to enforce the code. Of interest is a new requirement in 2021 for plain English wordings, termed PEAL, which stands for Plain English Allergen Labelling. There are 3 years to implement these regulations, which include ensuring that warnings are on labels whenever allergens are present, even if there are components of a food additive or part of a processing aid. Now, despite all these improvements, we find that food recalls are increasing. These are the statistics provided by Food Standards Australia and New Zealand, or FSANZ for short, FSANZ, showing the increasing numbers of recalls from 2011 to 2020. There's been a 50% increase. These are the mandated consumer recalls. Of course, there are a number of other recalls and withdrawals that may occur that are not mandated. If we look at the underlying reasons for the increase, we see that a significant factor is the more than doubling number of cases involving undeclared allergens. These undeclared allergens are shown in the blue bars on this chart. There's also been an increase in microbial contamination cases over this time. Conversely, some aspects are improving. The numbers of cases involving foreign matter have declined. 1 in 10 infants in Australia develop an allergy by their first birthday. Around half of the recalls due to undeclared allergens, such as nuts, egg, sesame, fish, soy, flour, whey, and gluten, are down to matters such as packaging issues and labelling matters. We find that in the UK there's a similar position. The British Society of Allergy and Clinical Immunology advises that 7% of breastfed infants develop an allergy. 1 in 5 children develop a peanut allergy by the age of 5, and similar numbers are allergic to cow's milk. This is replicated across the developed world. With all this increasing risk and safety issues, greater awareness, there's clearly an increasing need for businesses operating in the food and beverage industry to obtain insurance and have cover for losses of this nature. Such losses are typically provided by a contaminated product insurance policy. Such policies cover a number of matters apart from recall costs. As Adrian mentioned, they cover consultants and advisors costs, replacement costs, rehabilitation expenses, third-party recall costs, first and third-party business interruption, covers available for pre-recall costs, as well as for product extortion and tampering. I'd like to move on to give 3 examples of policy cover involving cases where microbiological contamination has occurred. The first example is of Leuconostoc mesenterioides contamination. This is a species of lactic acid bacteria. It is found on the skin of fruits and vegetables and is used to produce fermented foods such as sauerkraut and pickles. The bacteria is not considered to be dangerous to humans. On this occasion, tomatoes were stored in sacks placed within galvanized stackable containers ready for transportation. Fermentation accidentally occurred, resulting in the sacks expanding and damaging third-party containers. Attendance at site enabled the key issues to be examined, including assessment of the issues relating to the parties involved and the cause of the loss arising. As there was third-party property damage occurring, policy cover was triggered. However, it's notable if there had been no damage to the containers, the policy would not have responded to this incident. The second case involves Ralstonia silencerum, otherwise known as brown rot. This is a soil-borne plant pathogen producing bacterial wilt. Again, it does not cause disease in animals or humans. On this occasion, potatoes with brown rot were accidentally incorporated into products manufactured as chips, or in Australia known as hot chips. Several complaints were received of off-flavour chips. Samples were kept and examined. Olfactory tests were undertaken in random samples of frozen product. Record was made of a particularly rancid smell in the product, described as similar to smelly feet. Insurers agreed to provide cover, although there were no reports of any physical illness recorded. This was a significant loss with several thousand kilos of frozen product involved. Common with frozen foods, larger quantities of stock are produced and held in store than compared to ready-to-eat foods. Key issue in this case involved the determination of the extent of loss. How pervasive was the problem, and what quantities of stock could reasonably be withheld from the market for reasons of contamination. This was a matter for insurers to decide in line with the policy wording, guided by information obtained during inquiries. It was certainly a matter of protection of the insurer's reputation rather than any safety issue. The third example involves listeria, discovered in 1940 by Joseph Lister as listeriosis. Listeriosis is commonly caused by Listeria monocytogenes. Listeria is ubiquitous in the environment. It is pathogenic. In its overt form, it can result in a fatality rate of 20%. It causes sepsis, including meningitis and encephalitis. The Australian Food Standards Code specifies a maximum of 100 colony forming units per 25 grams in ready-to-eat foods. This follows internationally recognized methods for detection and enumeration of listeria. In this case, there was no trace of Listeria monocytogenes in finished cheese product, though it was present in the production premises and machinery. However, there was presence of other species of Listeria in the cheese. Examination of material obtained during inquiries by microbiologists revealed that there was a risk of Listeria monocytogenes release within some cheese products. For abundance of caution, the insured elected to withhold large quantities of cheese, presenting a claim for several weeks of interruption to production, including substantial associated costs of increased microbiological testing. The matter required detailed assessment of cause and the nature and extent of contamination, examination of facility design, cleaning and sanitation processes, class sampling and testing, virulence, strain differences, and the risks involved. Would the cheese cause injury or illness if released? When might production safely resume? Establishing what the extent of cover was in relation to these matters was critical. I'd like to move on to some other cases involving what might be termed weak links. Often in product recall matters involve issues concerning a chain of production and what might be considered a weakness in that chain. The first case involved eggs and salmonella. In New South Wales in 2018 and 2019, recalls were undertaken widely across the egg production industry. It was established that there had been reproductive tract infections in flocks of hens. 235 cases of illness resulted. There was culls of hundreds of thousands of hens within infested flocks. A review of biosecurity controls were undertaken, and requirements were increased regarding mandatory testing. The second case involves regulatory changes being overlooked and the production of a medicine. This medicine had been on the market since 1935 with an unchanged formula for over 80 years. The formula included chloroform as a small inactive ingredient. There were no reports of any illnesses or sickness received. The medicine had been grandfathered at the inception of the regulator, the Therapeutic Goods Administration. Although the medicine had been approved for use on a number of occasions by the regulator took the view that it would have been more appropriate for the product to have had a warning label stating the maximum dose. It issued a notice to the insured suggesting that a recall was appropriate. After taking advice, a recall was undertaken. However, there was significant loss of confidence in the product. The manufacturer entered into liquidation shortly after the recall was concluded. This was despite the insured settling the claim with insurers. In this case, the case involved application of policy limits for the cover. The metal in strawberries incident in Australia occurred or started on the 9th of September 2018 when a supervisor of a strawberry processing plant in Queensland placed needles in strawberries. Resulting copycat needle in strawberry incidents in Australia caused the wholesale price of strawberries in the market to drop by over 50%. Losses for this incident were calculated about $160 million. Needless to say, most soft fruit producers in Australia have had a hard look at the need for metal detection within their production process. The last case I'd like to mention is that of the frozen berries and hepatitis A. This was a global issue. Two particular incidents in Australia, first in 2015 and the second in 2017-2019 occurred. Losses were in the order of tens of millions of dollars. Significant publicity occurred. Quite a quote I remember from this one is that the press said that the only thing worse than finding a bag of frozen berries in your fridge would be to find a bag of frozen berries that were half empty. Other matters to look out for when it comes to weak links concern issues such as design innovations and the appropriate testing of such design changes, reliance on technology. With increasing reliance on technology, there may be a need for checking matters that might arise due to that reliance, and changes to standards of on production or government regulations. I'd like to just add by finishing to say that with all recall cases, and certainly with food and beverage, it's always a case of matter of preparing for the worst and being adequately testing your arrangements, making sure that you have planned for what may arise. We've seen many cases over the years where the best or worst cases are played out. It's important that everyone has the adequate scope and amount of cover. Have your team ready to go and take action as necessary. We can assess cause, loss, options, quantum, resolutions, and assist in obtaining recoveries and contributions. I'd now like to hand over to my colleague, Nick Patterson, back in the UK. Thank you.
Thank you, Martin. From Sydney to London in a click. And good morning, everybody. I'm going to talk about automotive recalls from a UK perspective. Apologies for that. But as automotive is truly a global market, claims will invariably be multinational and multi-jurisdictional in nature. It is worth pointing out that we are not just talking about vehicle manufacturers, but also the thousands of component manufacturers that make up the supply chain and aftermarket parts. First of all, I thought it would be useful to consider the number of automotive recalls in the UK over the last 2 years. As you can see from the graph below me, there was a peak in 2016, which has gradually declined through to 2020, but the general trend is definitely for increasing numbers. So why would that be? Well, there are a number of factors at play here, including increased legislation and regulation affecting the sector, and I'll outline some of them in the next slide. The fact that silent recalls have been outlawed for safety critical defects, which has forced greater reporting, has certainly driven the increase in automotive recalls. Technology and the use of more sophisticated products within vehicles failing in the supply chain has also caused an upward trend. Greater awareness for consumers, increased testing and capability to trace vehicles and their components, and the need to protect brands and the recognition that a well-managed recall can reverse some of the negative impact a defective product can cause to the brand image and reputation. I talked about increased legislation and regulations being one of the factors leading to a rise in auto recalls. So please excuse me while I just quickly focus on the UK landscape. The first is a case of Wharton v British Leyland, which established that there was a common law duty to recall unsafe products. This case involved wheels coming off Allegro cars, and despite mounting evidence that this was a serious safety issue, BL decided that a recall campaign, which would cost £300,000, was not justified. The judge in the UK found that manufacturers must warn past consumers about something which might result in injury. In the UK, whilst we were members of the EU, we passed the Consumer Protection Act of 1987, which implemented the EU Product Liability Directive, which is still good law, and which imposes a strict liability on producers of goods for injury and property damage suffered by consumers by reason of a defective product. And I have it on good authority, naming Martin, that you have similar legislation in Australia. The general product safety regulations are the predominant regulations which govern product recalls. The main obligation is that no producer shall place a product on the market unless it is a safe product. It is a criminal offence to breach the general safety requirement, subject to the defence that all due diligence was exercised in the supply of the product. Regulations also require clear and legible warnings and instructions on products, traceability by showing on the product or packaging the name and address of the producer, the product reference batch number, etc. They also cover sample testing, logging of complaints, and notifying distributors of results where a product may present a risk. Driver and Vehicle Standards Agency, otherwise known as the DVSA, is the enforcement agency in the UK, and there are obviously other similar agencies in other countries. The DVSA have wide-reaching powers which usually apply where voluntary action falls short, including suspension notices, requirement to mark or warn consumers, withdrawal notices, recall notices, forfeiture and destruction. I would in particular refer you to PAS 7100, which is a code of practice on consumer product safety related recalls and other corrective actions, which provides guidance on how to prepare a product incident plan. And finally, RAPEX. This is the European Rapid Alert System for for non-food products posing a safety risk to consumers. This is a live database covering 31 countries. I'd now like to drill down into some of the key points of an automotive recall in a little more detail. Automotive recalls are very complex, which in our view requires a forensic, multidisciplinary approach to the investigation and consideration of the claim, including engineering and accountancy specialism, which obviously Charles Taylor can offer in-house. When approaching an investigation into a recall claim, it is important to consider key factors, including design. So with automotive recalls, component manufacturers may take responsibility for components designed and manufactured by a third party. Important considerations such as the design criteria, specification, technical drawings, approval and sign-off process, all key considerations in establishing where the design responsibility lies. Contracts. The automotive industry has developed complex commercial relationships which reflect the complexity of the supply chain and are often subject to a number of regulatory jurisdictions. Ranging from bespoke supply contracts to one-party standard terms and conditions, it is essential to establish the contract terms as between the insured, their consumer, and their suppliers, including warranty periods and indemnities for breach of contract. Manufacture. It is essential to understand the process, what components make up the product, and what testing was undertaken during the manufacturing process and by who. Supply. So what are the distribution channels? These can be very complex indeed, involving multiple parties in multiple countries. Failure mode. Establishing the cause of failure or nature of the defect and how it arose is critical to the investigation of a recall claim. This is where a thorough root cause analysis, often involving specialists, sometimes referred to as an 8D report, is absolutely crucial. Dates. A thorough timeline is vital to determine the sequence of events leading up to the discovery of the defect. The population. You need to know how large the potential problem is, supported with comprehensive manufacturing records. Establishing which batches are affected between what dates, known as the bookends for production, is essential to understand the size and potential costs involved. And finally, cost. This includes the previous point, but will also include destruction costs, transportation, replacement costs, mitigation measures, crisis management, PR, and media costs. I'd now like to consider a number of case studies. The first one relates to a defective corner wind deflector, which was manufactured using metal retaining clips. Soon after the product went into the market, it became apparent that the corner plank or the wind deflector was beginning to fail. And it was established very, very quickly that 109 vehicles had this issue. It was particularly apparent when the vehicle was traveling at speed. And although, fortunately, there were no accidents involving personal injury, a vehicle in the mainland Europe was damaged when a corner plank or a wind deflector became detached from the vehicle. As a result of that, the issue was reported to the regulators, and they insisted that the population of 6,480 vehicles across 3 different types of vehicle were recalled. The root cause analysis determined that clips had been inserted on cold thermoplastic, contrary to the specification, and due to a lack of capability to automate the process within the insured's manufacturing processes. The next one concerns a defective regulator, which was again incorporated into vehicles, this time in their fuel pumps. The regulator casing was formed of 2 parts with a rubber membrane between the 2 sections. These were mated together in a hydraulic process. During routine cleaning, pressing sleeves were accidentally inverted, causing damage to membrane when the parts were mated together during the hydraulic process. The issue affected 100,000 units, but these were not identified until engines were started. There was no damage to third-party property or risk of injury, but the policy covered recall expenditure incurred by the insured due to their decision to recall the product. The policy extended to include product guarantee, covering the cost of removal and replacement of the product. And the final claim involves defective fill limiting vent valves, which were fitted to new vehicle fuel tanks, which caused the petrol pump or the filling pump to cut out, resulting in vehicle owners being unable to refuel. This is a very interesting claim because it involved a manufacturer in the Middle East who was supplied components from the Far East, which were then supplied into mainland Europe, where the tanks were manufactured, and these were ultimately supplied into vehicles which were delivered to the States. The root cause analysis determined that a flange, which was manufactured in the Far East, was undersized, causing distortion of the valve body, which in turn caused the float to stick. The use of the flange had been specified by the vehicle manufacturer. The insured maintained that they were not responsible for the flange and pointed to the pre-process application systems that were agreed between the parties, and it was alleged or argued that the responsibility for the flange remained with the with the petrol tank manufacturer. However, a detailed review of the contract fixed the insured with the design responsibility for the complete product, including the flange. Key policy consideration was whether damage to the fuel tank had occurred as defined by the policy. The definition of damage under the policy was sufficiently wide to accept that the fuel tank was damaged, as it could no longer, accept the fuel. And that ends my brief presentation. I now like to hand back to Glyn in Australia.
Thank you, Nick, and thank you to all of the presenters for providing very informative and useful information in relation to product recall across a variety of industry sectors. This is actually quite obviously a detailed and lengthy topic that we could go on for ages. Unfortunately, we only have a limited amount of time, and we have received some questions. Apologies if we don't get through all of the questions. I will ask a couple at random to our panelists. We will be able to, both in Australia and the UK, provide extra training sessions. Please feel free to contact us on LinkedIn or alternatively at the Charles Taylor website. So the first question, and this is one I will hand over to my colleague in England, that's Adrian. Adrian, what are the key challenges in dealing with recall claims?
It's all challenging. There are so many challenges, but sort of to lay them out in order, there's a lot going on. I mean, in terms of investigations with the insured have done something, or that something has happened where it's gone wrong. You've got to investigate that thoroughly, totally understand the insured, where they're coming from, the product that's been supplied, look at the technical information that's involved, appoint experts to assess that if required. In terms of challenges, probably the geek in me would refer to policy cover. You've got to look at that in detail and try and understand it as best you can. But I think probably the biggest challenge is the fact that it's a dynamic situation, that you've got a set of circumstances which can change to some degree, but really requires thorough investigation before you've got to the bottom of it. It's a mistake to make early assessments based on limited knowledge. There are always claims that require thorough, detailed consideration.
No, excellent. Completely agree, Adrian. And next question that has just come through to Martin. How critical is it to involve other professionals in the investigation of a claim?
Well, I think the key thing to look at the claims once we're involved is assessing the likelihood of the quantum. So generally, certainly on mandated recall claims, you're often looking at a significant loss. So you're looking at to determine whether the policy is going to respond, whether there's legal liability, what the cause of the loss is, and it's critical that those points are all adequately covered, so that our principals get a good reserve and get a good outcome to the claim, both for the insured and insurers alike. There's often significant professional expertise within the insured themselves, but more often than not, there's cases arise where determining cause needs us to bring in professionals from outside if necessary, so forensic engineers. Regarding quantum, often there's complex issues arising regarding calculation of costs and claims and assessment of losses. So matters such as forensic accountants, either in-house or from others externally, is often needed. So it can be critical in all cases to make sure that we establish the amount of the loss and the liabilities arising. So it's I would say, depending on the case, if there's no policy cover, then you might not need any expert. But if a large case, more often than not, you need to be making sure you've got the appropriate advice, and to that, it's often need professional expertise externally. Depends on the case.
Totally agree. Thank you very much, Martin. Last question, and apologies for those people who are actually sending questions in that we can't get through to you. We will certainly respond, and obviously a copy of this presentation will be issued to one and all. Last question, Mr. Patterson, you're not going to get away with it. The insured will often have a commercial relationship that they are seeking to protect. Obviously very important that we manage this very carefully with the insured. So the question is, how do we manage these situations with the insured? Thank you.
Yeah, thank you, Glyn. I suppose the question really is asking us, how do we work with the insured to protect their brand and also to protect their relationship with their customer. I suppose as adjusters, we tend to take a slightly different approach than perhaps other professionals, in that we, obviously, pandemic permitting, often meet face to face with the insured and other stakeholders, and we build that rapport, which I think is critical in actually making sure that we understand the dynamics in play and understand the drivers that are pushing the insurer forward in terms of what they're doing and their actions, and the consequences of those actions in managing that recall. As adjusters, a proactive approach is essential. We need to be clear about the documents that we require, by whom, from whom, and when we need them by. We need to ensure that the actions are recorded and agreed, and that everyone understands the importance of making sure that there's good communication flow between the insured, the insurer, the adjuster, and often the broker that often plays a part in product recall claims. We have to respond to situations quickly and effectively, making it clear what is within our scope of authority and what is outside, and where we need to refer to insurers. And I suppose finally, and it's the golden rule, is try and make sure that there are no surprises. Make sure that they understand where you're coming from, why you're coming from that particular direction, and where you want to go in terms of working with them to protect the brand and to protect their reputation with their customer. Hope that covers that off.
Thank you very much. It certainly does. Very informative. A huge big thank you to all our presenters over in the UK, to Nick and Adrian, where it's approaching 11 p.m. at night, so you'll be able to go to bed soon or have a glass of wine or whatever it is. To Martin, thank you, sir, for your input as well. And thank you to absolutely everyone for taking the time out today. Please do take a moment to fill out the survey at the end of this presentation. So from everybody here to everybody in Australia, hope you have a good day. And those who have tuned in back in the UK, Ireland and Europe, have a good night. See you soon. Goodbye.
Thank you.
Thank you.
Thank you.